People are on probation. They're excited about getting probation because they thought they were going to prison. And people will stand before me and you know what they will say?
Yes.
I can be on probation for life. I'm pulling my life together. You can ask me to report every day. I'll do it. I already know that's not going to happen. M40, State of Texas versus Bernardo C. Huerta. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Meredith Chacon for Mr. Huerta, Your Honor.
And are you Bernardo C. Huerta?
Yes.
Are you the same Bernardo C. Huerta who was placed on community supervision in 2022 CR 6940 for the offense of robbery on July 18, 2023 for a term of 8 years? Is that you?
Yes, ma'am.
State?
Violated condition number 39 on or about the 30th day of April 2024 in Bexar County, Texas. The defendant, Bernardo C. Huerta, did then and there fail to participate in the mental health initiative, evaluation in custody, and comply with all rules, regulations, and instructions as directed by the court and or supervision officer in violation of condition number 39.
How do you plead to that? True or not true?
True.
All right. So if y'all want to go back and discuss things.
Okay.
All
Thank
right,
you, Judge.
thank you. You're welcome. All right, Mr. Huerta, it's the court's understanding you've had time to speak to your attorney
Yes.
in regards to your plea of true?
Yes, ma'am.
All right, do you still wish to plead true to violation of condition number 39 after speaking to counsel?
Yes, ma'am.
All right, did you understand by pleading true to violation of condition number 39, court could find it true, grant the motion, and sentence you up to 8 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 39?
Yes, ma'am.
All right, the court will find violation of condition number 39 true. Is there a proposed agreement or no?
No, there is not, Your Honor.
All right, state, what are you requesting?
We're asking that you follow probation's recommendation, Judge, which is to alter and amend conditions for DDRF and to hold the probationer, hold Mr. Huerta in custody until the Center for Healthcare Services, the Tacoma evaluation, the TCOOMMI evaluation for DDRF is completed, Your Honor.
All right, defense, what are you requesting?
Judge, my client has been in since January awaiting the DDRF. The wait is very, very long for DDRF. There was, yes, he's pled true to not doing the eval. He did a part of an evaluation and thought he had completed the entire thing. But he would like the opportunity to do some sort of outpatient. Our understanding is the wait for DDRF is 6 or 7 months long, potentially, which means he will be sitting in jail almost a year by the time that happens. And so is there anything, may I ask him if there's anything else?
Sure, but I will tell you, if you would have agreed to see them, you would have been done.
Yes.
And your 6 months would have been done.
Can I, whenever.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Bernardo Huerta.
All right. What
Yeah.
would you like to say?
Yes, ma'am. I do understand that, but it's still a 6 to 7 month wait. I have almost 2 years back time on this case already, just sitting in the jail.
Oh, do you just want to go to prison?
No, we don't. I don't.
All right, so here's the
But
thing.
I don't
Let's
have
talk,
to-
no, stop. Let me explain something to you for a moment. Let's go off the record for a second. I don't know why people commit offenses. You plead to the offenses that you committed. You're placed on probation. You get a motion to revoke. The reason why you have the DDRF pending is because you were here for a motion to revoke a violation of condition number 4. Guess what? If you were not placed back here for a violation for your motion to revoke, you never would have been waiting for a mental health evaluation. What ends up happening is people are on probation. They're excited about getting probation because they thought they were going to prison. And people will stand before me and you know what they will say?
Yeah.
I can be on probation for life. I'm pulling my life together. You can ask me to report every day. I'll do it. I already know that's not going to happen. It's sort of like when people say, I'm 1,000% sure that I'm clean. You know what that usually means? They're dirty. Anything anybody says that's beyond 100%, it's usually not true.
Yes.
So you came before me with that. You were placed on probation July, then February 2024. You had a violation of condition number 4. And I remember you. You came before me. You were so happy to be continued and not be revoked. And now you come before me.
I haven't
And
gone nowhere.
here's the thing though.
I haven't gone out of jail. I've
Here's
been in jail
the
this whole
thing.
time.
Here's the thing. But the reason why you're in jail is because of your actions.
Yes, Your Honor, I understand
And
that.
people will come before me, and let me just tell you what happens. Some people will come before me and they'll say, I don't belong to a gang. I don't do drugs. Or I pay child support. And I always ask people when they would say, I pay child support. What, you want a cookie? That's something you're supposed to do. Like, you're not supposed to be before me on motions to revoke because you're supposed to be doing what you're supposed to be doing. And whenever I give people conditions, or whenever probation recommends conditions for them, they want to write their own program. If you could write your own program, guess what? I wouldn't have a job. Defense attorneys wouldn't have a job. The state wouldn't have a job. It would be great. But you can't appear before the court and then decide that you're writing your own program and you deciding that you're not going to follow through and speak to the person. If you would have spoke to that person in April, your 6 months would have been done. You would have been either in DDRF or not. They would have transferred you. But you know what? You've been pushed back. You know why you've been pushed back? Because you did not want to do the other interview because you're like, I'm done. And I always tell people when you're on paper, and that's what this is a contract, you're on paper. Even if somebody tells you, we're coming here for an interview, and even if you've thought you've already done the interview, doesn't hurt you to go ahead and do the interview, then you can come to court and say, they came to me for an interview for a 3rd time, and I had already done the interview. Then we can discuss that. But when you don't follow through on what you're supposed to do, guess what ends up happening? Everything falls and you get placed at the end of the line, because guess what? There's somebody there who's on probation, who had to be interviewed for mental health and DDRF. And guess what? They took your spot. That's where we are.
That's the only thing. I'm just seeing a lot of people coming back, a lot of time waiting for it.
Yeah. I mean, I make rulings and there's a reason why these rulings are made. Right? And then you're also on, I believe you're on gang supervision as well.
I'm not sure.
Is he on gang supervision?
Sorry about that.
Well, were you a previous gang member?
I used to be, yes.
All right. So he was on gang supervision. So I have somebody standing before me who is on gang supervision. You know, you're given probation, the state recommended community supervision. And then you're over here pulling stuff off or trying to pull stuff off. That's why you have the DDRF. Now, if you don't want to wait for DDRF, I can revoke you. You guys can talk over what time you want, and I'll do what I will with regards to time. And guess what? You'll go to prison, you'll do your time, you'll get out. Either you're going to act right and follow the rules and conditions of society, which don't pick up any new offenses, take care of your children, stay on the straight and narrow. If you don't, you'll probably end up being a habitual, and your minimum when you come back will be probably 25, or maybe it'll be as a repeater in which case your minimum will be 15, depending on the charges. So if you want to discuss with the state and your attorney about doing your time, then you can do your time. And legally, I have to give you credit for any time that you've been in custody towards your time. So if you want to talk to your attorney about that and talk to the state about that, I'm not saying if they agree to revocation and they want to give you a specific amount of time, I'm not saying I'm following that, but I'll consider it. All right. So if you want to talk to your attorney about that, you can.
Mr. Huerta, we talked over the break about whether or not you would agree to go to DDRF, and you've indicated that you do not want to do that, correct?
No, I'm trying to get an outpatient program.
Okay, and knowing that that's not an
Now,
option,
just 1 second. I'm sorry. I don't know if the court reporter heard his answer.
can you repeat that?
I was trying to get an outpatient program. No,
Okay. The last part?
but if it's not possible,
All right. So you're trolling off. So my understanding, and correct me if I'm wrong, your answer to the defense counsel question is you're trying to get into outpatient treatment.
Yes,
Is that
ma'am.
correct?
yes, sir.
Oh, it's fine. He's just mumbling. And if you're not able to get into outpatient treatment, then what was the next thing you said?
Um, and I'll figure out what happens.
All right.
Mr. Worth, I explained to you the only options in front of you are DDRF, if you agree to it, or that we have a sentencing and the judge will determine how much time you receive. Do you understand that?
Yes,
And since outpatient is not an option, would you like to avail yourself of the opportunity to do DDRF? Or do you want to be sentenced today?
I guess we'll sentence.
Okay. And I advise you to go with DDRF, correct?
All right.
That's all I had to put on the record, Judge.
Thank you. All right, so he's pled true to violation of condition number 39. Is there a proposed agreement?
There's not, Your Honor. I would ask the court, I know that the defendant has stated that he would like to be sentenced. I don't think you should do that. I think you should say, hey, you're going to the inpatient. That's, I think that's a better option for him. If, I know he said he wants to be sentenced, but, and I can speak to that if the court would like to.
Sure. I mean, here's the question, Mr. Huerta. You don't get to decide whether you're in inpatient treatment or outpatient treatment. Now, they want to interview you for DDRF. Either you're going to do that or you're not going to do it. So, do you want to be interviewed for DDRF? Yes or no?
Yeah, I guess.
No, it's not I guess. It's either yes or no.
Yes.
You can't write your own program. Here are your options. Your options are you can be interviewed for DDRF. And if they deem that you're acceptable to the program, that's where you're going to be. Or if you don't want to do that and you tell the court you don't want to do that, then I will revoke you. Those are your two options. Now, if the court were to revoke you, then the most I could sentence you to is 8 years. I'm sure your attorney will ask for something probably less than 8.
20 years just to deferred.
No, he's not on deferred. He's on regular.
He's been adjudicated? Oh, okay.
Yes. So,
I was on deferred also. Okay.
no, he's on regular. So the most I can sentence him to is 8 years. So, and he legally, I have to give you credit for any time served that you've been in custody. So those are your options. Do y'all need to discuss this again or no?
Do you want to do DDRF or do you want to be sentenced?
I'm talking to
That's not an option. The judge has told you and I've told you there's two options. Sentence, we don't know how much time, up to 8 years. Okay, to be.
All right. So you want to be sentenced?
Yes,
All right. You've pled true to violation of condition number 39. Court is finding violation of condition number 39 true. State, what are you asking for?
We're asking for the 8 years, Your Honor. The defendant has been to the prison in 2010 for an ag assault with a deadly weapon. I know you've seen the SIPs in this, and I know it's a robbery, Judge, but it came in as an ag robbery. This was, the defendant was stealing from an O'Reilly's. When the employee tried to stop him, he pulled a knife on the plain witness in this case, Judge. So this is an inherently scary crime, Your Honor, and so that's why we're asking for the 8 years, Your Honor.
All right. Defense?
The client would ask that you give him the minimum of 2 years and credit for time served.
The court is going to grant the motion. The court will sentence you to 8 years in the prison. The court will give you credit for any time served. There's to be, just one moment. There's to be no contact with Abel, Abel Ramos, and O'Reilly's located at 955 South General McMullen, San Antonio, Texas 78237. And there is to be a $500 fine. Time and money will run concurrent. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it?
yeah,
All right, you have a limited right to appeal, and that right to appeal is as it relates to the allegation in the motion, not the fact that you're on community supervision. Do you understand?
Yeah.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you, okay? Calling 2023 CR 9473, State of Texas versus Joe Edward Serta. Can I have parties announced for the record for the state?
Brandon,
Defense.
Brandon Lopez for Mr. Soto.
All right, are you Mr. Serta?
Your Honor.
All right, you entered a plea of no contest. And we're set here for a sentencing. According to the plea bargain agreement, state is opposed to your application for community supervision or deferred adjudication. Have both parties had a chance to review the PSI and the TAP evaluation?
Your Honor, I believe this was just a
Tap.
tap because he was, he turned himself into Atascosa for, Saturday.
On the 29th of December.
That's true. That's what I'm reading here. All right. So state, are you still opposed after reviewing the TAP evaluation?
Yeah, and I think Hank has the,
All right. Do you know if Hank is still opposed?
Your Honor, he hadn't mentioned any sort of change.
All right. So then I'll make my decision.
But I think we're opposed. My understanding is that he just has quite a few DWIs in this history.
All right. All right, probation.
Yes.
On this case, you all are recommending outpatient treatment. Even though you all are recommending outpatient treatment, will you all still let me refer him to inpatient treatment?
Yes.
Okay. And do you know whether or not felony Veterans Treatment Court reviewed his case here in Bexar County?
I'm not sure, Judge, I have to check.
They have not as of yet, is my understanding.
Okay.
And I understand that they can do that post sentencing, so we
Yes.
were gonna proceed.
All right. So, Mr. Serta, here's the issue with you. You do have a lot of DWIs. I take into consideration that you are a veteran. You were not good on the ignition interlock either. So one or two things can happen because I don't like putting problems off on other people. It's obvious to me that you have a alcohol problem, which is a drug. And they're asking for your punishment to be at 6 years. And what will end up happening is you would be out in 6 years, probably out in 3. And you would still be allowed to drink alcohol if you so choose. So I can sentence you to the 6 years, or either I will place you on probation for 10 years. And you're going into inpatient treatment.
Yes, Your Honor. I believe I'm going to in Atascosa County as well for six months.
So they're asking that you go to SATA.
He's already been sentenced to status through Atascosa.
Well, I'm gonna put him in safety.
Right, my understanding is he'll do both.
Well, somebody should probably talk to Atascosa because if Atascosa see that he's going to safety, they may want to not have him go to SATA. They may just count safety.
And we can arrange it.
All right.
Yes.
Court is going to sentence you to 6 years in the prison, suspended and probated for 10 years. There's a $500 fine that will be probated. I'm going to ask for a referral to felony drug court and to Veterans Treatment Court. We'll try Veterans Treatment Court first. I'm going to order safety. 10 days in the Bexar County Jail as a condition. 2 years license suspension. Ignition interlock for the full term. And I'm saying full term now, counsel, but that may change.
Again.
Victim impact panel, live. DWI intervention, DWI education, 90 sober meetings in 90 days, regular reporting by Zoom or in person, regular random UAs, 200 hours of community service restitution, field visits, one time per month for 6 months, then at probation's discretion. And he's to remain in custody until transfer to safety. Probation, is there anything else he needs? Thank you. Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors.
And Your Honor, the final thing I'd ask is, can we get an order to remove ignition interlock? He's a vehicle that he's obviously not driving, that's on the outside, that has ignition interlock.
Yes, once you present that order to me, and we'll make sure it's a smooth transition where the ignition interlock is off and then immediately back on when he's, I would say 2 weeks before he's released from custody, ignition interlock needs to be back on the vehicle.
I'll put that in order.
All right. Probation, is there anything else?
No.
Is there anything else you need from the court to be successful?
No, Your Honor.
All right, I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. The reason why you're receiving this probation, there are a couple of reasons. Main reason is because your minimum sentence that you agreed to is 6 years. If you just go to prison and don't receive treatment for your alcoholism, what's going to end up happening, because alcohol is not illegal, you're going to get out, you're going to think you're fine, you're going to have a slip up, and you may end up killing somebody. And number two, because you serve your country as a veteran. You understand?
Yes, Your Honor.
So in this court, in order to be successful at probation, you need to make sure you communicate. Communicate with probation. If you feel as though they're not addressing it, you can always come back here. And you need to be honest with felony drug court and honest with veterans treatment court with your addictions. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
This case serves as a powerful reminder that probation is often an opportunity, not a guarantee. Bernardo Varta admitted violating a court-ordered condition, but the defining moment wasn't the violation itself. It was what happened afterward. Judge Boyd repeatedly offered a path through treatment and rehabilitation, while emphasizing that probation requires compliance, accountability, and cooperation. Bernardo instead chose sentencing, and after considering his criminal history and the underlying robbery conviction, the court imposed the maximum 8-year prison sentence. Whether you agree with the ruling or not, the lesson is clear. Ignoring court-ordered requirements can carry consequences far greater than many defendants expect.